Colleagues, ladies and gentlemen, I'd like to call to order this meeting of the Standing Committee on Justice and Human Rights. I am very thankful that we're joined by our Minister of Justice and Attorney General, Jody Wilson-Raybould, who will be talking to us about Bill C-75. And this is the beginning of our hearings on Bill C-75. I know that we only had the Minister until 5 o'clock, so I want to give her all the time that we can. And so I'm going to turn it over to you, Madam Minister. Thank you for joining us.
Well, thank you very much, Mr. Chair, and thank you, as usual, to members of the committee. I think I was just here very recently, but it's good to be back. So today, as you say, I'm here to speak about Bill C-75, an act to amend the Criminal Code, the Youth Criminal Justice Act, and other acts, and to make consequential amendments to other acts. Bill C-75 seeks to modernize the criminal justice system, reduce delays, and improve the safety in our communities. It also proposes significant new measures to address the overrepresentation of Indigenous people and marginalized Canadians in the criminal justice system. Delays in the criminal justice system are a long-standing issue. The Supreme Court of Canada has pronounced on this important issue several times. In 1990 in Ascoff, in 1992 in Morin, and more recently in 2016, 2017 in the decisions of Jordan and Cody. Their direction to us is clear. We must change the culture of complacency that exists in the criminal justice system or risk having charges stayed for violating an accused's right to be tried within or without delay. This is exactly what Bill C-75 seeks to do. It proposes criminal law reform in 7 key areas. First, the bill will modernize and streamline the bail system. Second, it will enhance our approach to addressing administration of justice offences, including for youth. Third, it will bolster our response to intimate partner violence. Fourth, the bill will restrict the availability of preliminary inquiries to offences which are with penalties of life imprisonment. Fifth, it will reclassify offences to allow Crowns to elect the most efficient procedure appropriate in the circumstances. Sixth, it will improve the jury selection process. And seventh, it will strengthen the case management powers of judges. As a former prosecutor, as an Indigenous person, and now as Minister of Justice, I am convinced that these proposed reforms will have a positive impact on criminal courts across the country on a daily basis. I invite the committee to study all areas of reform and to think about their cumulative impact in combating delays. Let me begin by stating that I take very seriously the mandate I have been given to address the overrepresentation of Indigenous peoples in the criminal justice system, particularly in remand centres, where there are more people awaiting trial than there are individuals who have actually been convicted of an offence. I recognize that other marginalized groups, people struggling with homelessness, Black Canadians, those with mental health and addictions issues, face these challenges as well. The proposed bail amendments will enact a principle of restraint for the police and courts to ensure that release at the earliest opportunity is favoured over detention and provide more guidance to police on how to impose appropriate conditions without impacting public safety. The proposals will also include a requirement that the circumstances of accused persons who are Indigenous or come from vulnerable populations are considered at all stages in the bail process in order to address the disproportionate impacts that the bail system has on them. The second area of reform will enhance the approach to administration of justice offences, such as breaching a curfew condition or a sobriety condition of bail. Processing these administrative offences is consuming court time and resources at an alarming rate, and preventing courts from efficiently dealing with more serious matters. This bill will result in fewer charges for these offences by creating a new process called a judicial referral hearing. The hearing will be an alternative to laying charges for breaches of bail and failures to attend court in cases where there has been no physical, emotional, or financial harm to a victim. The third area of Bill C-75 that I will discuss is our strengthened response to intimate partner violence. The bill will toughen our laws in cases of domestic assault. It establishes higher maximum sentences for repeat offenders, provides a reverse onus at bail hearing for repeat offenders, and recognizes strangulation as an elevated form of assault. As well, the bill modernizes our laws by broadening the parameters of intimate partner violence, which will now include a current or former spouse, a common law partner, and a dating partner. These changes will make victims safer and will respond to the seriousness of intimate partner violence. The fourth key area of Bill C-75 that I would like to note is the proposal to restrict the availability of preliminary inquiries for adults accused of offences liable to life imprisonment. As I've said before, this proposal will significantly reduce delays and efficiencies in the criminal justice system. That is why, in its 2017 final report on delays, the Senate committee recommended that preliminary inquiries be restricted or eliminated. That is why many of my provincial and territorial counterparts called for this reform. I acknowledge that overall preliminary inquiries are only held in a small percentage of cases, but they are consuming a disproportionate amount of time in a number of provinces. These reforms are expected to have a significant impact in those provinces where preliminary inquiries are more common and will have a cumulative impact overall. I will now discuss Bill C-75's proposal to hybridize a number of offences in the criminal code, which unfortunately has been mischaracterized. This reform will mean that prosecutors will have the discretion to prosecute alleged crimes either by way of indictment or by way of summary conviction. Hybridization of straight indictable offences punishable by a maximum of 2, 5, and 10 years will have the following effect. Cases involving serious facts and circumstances will still be prosecuted on indictment and will still face the current maximum penalty. However, for cases involving less serious circumstances, the Crown will have a choice: proceed on indictment, or, if similar cases have resulted in much shorter sentences, consider proceeding summarily, where the same sentence will result, but likely more quickly. Let me be extremely clear. Reclassification reforms are not about lowering sentences. Serious conduct will continue to be treated seriously by the courts. This is one of the bold reforms that we expect will have a fundamental cumulative impact on delays in the criminal justice system. I would also underscore that this reform is strongly supported by the provinces and territories. I am proud of the many other reforms being proposed in Bill C-75, including with respect to improving the jury selection process. Abolishing peremptory challenges will follow long-standing reform recommendations in this country, the experience of other countries, and will finally put an end to potential jurors being excluded from serving as a result of baseless speculation, stigma, or discrimination. Finally, I would like to draw the committee's attention to the legislative backgrounder on Bill C-75 that I tabled on May 31st, as well as the accompanying charter statement. I hope that these documents will help guide your study by explaining in more detail the intent of the proposed changes. Mr. Chair, those are my comments, and I very much look forward to the questions of the honourable members.
Thank you very much, Madam Minister. So we will turn it over to the Conservatives. Mr. Nicholson.
Thank you very much, and thank you, Minister, and thank you to those who are joining with you here. Let me just talk a little bit just about the procedure and get your thoughts on this. This is a huge bill with lots of changes to the criminal justice system. It's over 300 pages, and as you say, it goes into so many different areas. I was somewhat surprised that when we finally started second reading debate, Mr. Cooper and I and another of our colleagues, we all got up to speak, and then I was informed, I think it was the next day, that time allocation has come in to shut down the debate on this. And so I'm not going to start arguing about that, but wouldn't you agree, or would we have your support that this is not something that should take place when it's at third reading, because it's important that Parliament debate these different issues here, and that they should not be quickly shut down? Because there was no suggestion on, I'm sure, myself or Mr. Cooper's part, that we were going to somehow keep talking about this ad infinitum anyway. Thoughts?
Well, I I hear the question from my colleague in terms of procedure. I would say with respect to C-75, we now have the opportunity to continue to engage in discussions around these important issues which seek to address delays in the criminal justice system, a topic that we have been having discussions around for 2.5 years. Certainly I have benefited and we have benefited through what we heard report to provide feedback on roundtables that we've held across the country. We've benefited from Senate committee reports, but I very much look forward to what has always been the thoughtful consideration and recommendations that come from this committee, and certainly recognize the opportunity to meet with numerous witnesses with respect to all the different aspects of the bill.
Well, thank you for that. But again, I'm hoping that when the time comes that we do debate at third reading, that the importance of this bill will justify having a considerable debate without cutting it off initially. With respect to the hybridization of the offenses, I mean, we're talking about over 100 proposals to make indictable offenses also eligible for summary conviction. This could, and I've heard from some people at the provincial level, that this may fill up the provincial courts and jam the provincial courts as opposed to the superior courts if they opt for the summary conviction. But you say that the provinces were overwhelmingly in support of this, and was it something formal they said, or was it informal discussion? Who exactly has, at the provincial level, has been pushing for these?
Well, thank you for the question around the reclassification of offences, hybridization. As I had the opportunity to indicate to this committee before, and I'll reiterate, we engaged in many conversations, myself with my counterparts in the provinces and territories, the attorneys general, at two formal federal, provincial, and territorial meetings, as well as in between. We continue to have conversations at officials levels, as well as at my level, around various types of reform that we could collectively put forward given the shared administration of justice responsibilities that we share. We, at the first FPT meeting and then at the subsequent FPT meeting, confirmed 6 areas of bold reform, and that was the word of the provinces, the bold reform, but certainly I support the bold reform that we are proposing in many areas, including the reclassification of offences. This was one of the areas that my colleagues in the provinces and territories were supportive of.
Well, I'd be very interested to hear some of them before this, because, as I say, I've heard that some of them are quite concerned the provincial courts are going to get jammed. But with respect to the clogging up of our courts, if we give the opportunity, for instance, somebody participating in a terrorist group, if that person has the opportunity to have that reduced to a summary conviction and have the possibility, I suppose, of even a fine, I mean, in one sense, I suppose that would speed up the process here, because if you're a member of a terrorist group and you get the option of getting a summary conviction, and or if somebody says you're going to have to pay a $1,000 fine, I could see, yeah, you wouldn't be taking up much time in the court system. You'd say, jeepers, give me that one and I'm out of here. But on the other hand, there are people who would seriously question whether the whole list of these offenses are of the type that they should ever have the possibility of having a summary conviction or a very low penalty, that they in and of themselves are very, very serious. But have you been getting any back feed on this? Are people talking to you supportive of reducing the possibility of these penalties?
Well, thank you for the questions. Certainly, with respect to the clogging up of the provincial courts, I would again reiterate the need to consider C-75 in its entirety in terms of the impact that it will have with respect to delays. In terms of the 136 offences that we're seeking to reclassify in the criminal code, we have done extensive work around that. I would say with respect to the reclassification, as I said in my remarks, this is not about changing sentencing. This is about providing additional tools to prosecutors to exercise their discretion given the facts and the circumstances of a particular individual that comes before them. This is not about changing the fundamental principles of sentencing in terms of consideration around the proportionality and the gravity of the offense, the responsibility of the accused person. That will be determined based on the offense and the circumstances. I will say, with respect to terrorism offenses, there is a difference in terms of how offenses are committed, the gravity of the offense, the proportionality, the responsibility of the accused person in whatever the situation is. And as my honourable colleague will likely know, the Supreme Court of Canada has weighed in terms of terrorism offenses not having different principles of sentencing around terrorism offenses. There are a number of examples in terms of offenses, from terrorism offenses to impaired driving causing bodily harm, to other offenses that can be committed in many different ways, and we have to ensure that we're providing tools to the prosecutors and then the judge who will ultimately make the decision on sentence, the necessary tools to determine which way to proceed, because a number of the sentences, whether they be whatever offense, could and have been shown to be less than what we're proposing in terms of 2 years less a day for a summary conviction offense. And if a prosecutor proceeds by way of summary conviction, it will assist in alleviating some of the burdens in terms of the highly procedural aspects when proceeding by way of indictment.
Thank you. Mr. McKinnon.
Chair, and thank you, Minister, for being here today and for championing these reforms contained in C-75. I just want to start by following up on a point that Mr. Nicholson made. He seemed to suggest that with hybridized offenses, the accused might have an option of choosing summary conviction versus an indictable offense. My understanding was that would be an option, such as it exists, would be an exercise only by the Crown based on the circumstances of the case. Could you clarify that for me, please?
Oh, so I hope I didn't misspeak in that regard. The option to proceed by way of summary conviction or by way of indictment is an option that is provided to the Crown prosecutor. It's not at the option of the accused person.
Okay. I don't think you misspoke. I just perhaps didn't. I needed some clarification on my own. So.
Thank you.
So what I'd like to talk about today actually is bail reform. So we know that according to police and court statistics, over half of the people currently in provincial and territorial detention facilities have not yet had a trial or have been found guilty of an offense. And as members pointed out during House debate, marginalized and vulnerable groups, including Indigenous people, are overrepresented in this group of people being detained before trial. And there's also a self-sustaining and self-perpetuating cycle of interaction with our criminal justice system. Court time and resources are disproportionately allocated to address breaches of police conditions or court conditions for bail. And many of these conditions are unrelated to an offense and do not actually serve to maintain public safety. Instead, they place unnecessary burdens on vulnerable individuals, including Indigenous Canadians, creating a pipeline to the prison system and making it difficult to break out of this cycle. So with that in mind, I hope you could comment further. You mentioned these aspects in your remarks, but I hope you could comment further on what action is being taken to break this cycle and to ensure that the bail process is fair and equitable for marginalized groups, and particularly for Indigenous peoples in Canada.
Well, thank you to the honourable member for the question, and it is a vast question with many different areas in terms of action that are necessary to address the challenge and the sad reality of the overrepresentation of Indigenous peoples, in addition, the overrepresentation of individuals in the criminal justice system that are suffering from, as you quite rightly point out, mental illness and addiction issues. This is something that I have and our government has been working very diligently to address. That doesn't just, or this reality isn't just impacted by the numbers in the criminal criminal justice system and impacting on my department, but is a reality of homelessness, a reality of poverty, a reality of the colonial legacy if we're dealing with Indigenous peoples, and the lack of services and the need to invest more in those services. That's something that our government is working very diligently on, have committed and provided resources to, because we recognize that we do not, as you say, want to continue to have a revolving door in the criminal justice system. A lot of these measures to address this reality are measures that are being taken and need to continue to be taken outside of Bill C-75, but specifically in terms of what we're proposing, and you referenced the bail reform that we are putting forward that's contained within this proposed piece of legislation. This bill will help address the issue and the reality of Indigenous peoples, other marginalized Canadians at the bail stage. As you say, they are overrepresented at that stage by, one, as I said, enacting the principle of restraint in the bail regime to ensure that where there are no concerns of the accused being a challenge in terms of public safety, that judicial release of that individual is considered. We're also requiring that conditions imposed by police be reasonable and necessary in the circumstances, and that law enforcement officers and others take consideration of the reality of Indigenous peoples and the circumstances, particular circumstances they face, as well as other marginalized Canadians in the justice system. We think these measures will lead to and assist in the reduction of the individuals that are currently in remand for administration of justice offences.
Thank you, Minister. Along the same lines, I want to talk about...
You only have a minute left.
My question is longer. I'll pass.
Thank you, Mr. McKinnon. Mr. Rankin.
Thanks. I appreciate it. And good afternoon, Minister. Thank you very much for joining us as we begin this journey on C-75. I hope we're going to have ample time to thoroughly review it and discuss its merits and shortcomings in detail in the fall. I have two specific questions I wanted to ask you about, and hoping that they would be amenable to amendment. The first involves the routine police evidence question, and the second involves some of the implications of raising the minimum penalty for summary convictions. Perhaps I can start with the routine police evidence one. You know, it's pretty rare when you consult people from across the spectrum, academics, practicing lawyers, different parts of the country, to come to get essentially unanimity, which is the case in our situation. When I asked these people about the problematic components of this legislation, one on which everyone agreed was that the section involving police-based police evidence being adduced by affidavits, section 657.01, is in desperate need of amendment. So the routine police evidence language in the bill has been called too vague, creating an opportunity for abuse. For example, University of Alberta law professor Peter Sankoff went so far as to write that it is, quote, extremely dangerous, close quote. I think that makes a lot of sense for lab results and other routine evidence to be at issue and submitted without requiring a police officer to come to court and testify. I'm totally in agreement with that. Indeed, I think that's probably what was intended. But the drafting of this section could allow even eyewitness testimony to be submitted in this way. So, you know, I understand defense counsel could come forward and cross-examine, ask for the right to cross-examine, and the courts are going to say yes. But that's only going to cause more delay, and you've told us delay is your agenda in this bill. And in addition, many self-represented individuals, poor, marginalized, folks who can't afford legal aid, are going to not know what to do, causing delays, and I say sometimes even injustices. So my question, can you commit to accepting amendments to this provision so it's narrowed and clearly defines what routine police evidence consists of?
Well, thank you for the questions and the commentary, and I do recognize that there has been commentary on various aspects of this legislation, including routine police evidence. I guess the short answer to the question is, as always, I am open to considering amendments. I certainly, we're talking about routine police evidence. I look forward to hearing from the witnesses that will come before this committee with respect to potential clarity around the meaning of routine police evidence. Again, this measure was put into this bill to assist with respect to delays around that routine police evidence, leaving the discretion to the judge in the particular situation to determine based on the interests of justice. Again, short answer is look forward to hearing the debate.
Thank you, and I appreciate that. The second issue is the implications of the summary conviction maximum penalty being raised to 2 years less a day. The concern that has been raised, as I think I expect an unintended consequences of that, according to Professor and lawyer Emily Taman, among others, is that currently the default maximum sentence for summary conviction offenses is 6 months. However, in the case of more serious offenses, the maximum penalty, even where the Crown proceeds by way of summary conviction, is between 6 months and 2 years. For example, assault causing bodily harm, 18 months. The concern is that agents like law students and paralegals currently can represent people accused of any offense where the maximum penalty is 6 months or less. In other words, paralegals and students can represent people for only the less serious summary conviction offenses. Assault causing bodily harm is one I mentioned. So the concern that has been expressed is that by proposing to raise the maximum penalty for summary convictions to 2 years less a day completely gets rid of the possibility of agent representation, which is going to cause delays in the system because many accused persons won't have any legal representation at all. And we're talking about poor, Indigenous, marginalized, and the like who can't afford legal aid in so many of our jurisdictions. Lisa Cirillo, Executive Director of Downtown Legal Services at the University of Toronto, stated, quote, "We feel there's such a huge access to justice issue in our country. We feel like they couldn't have meant to wipe out the ability of all these clients to access legal assistance." So my question is, can you tell us if restricting agent representation in this way was in fact intended? And if not, can you commit to amending the bill so as to avoid this unfortunate outcome, which will cause only further delay and affect those who can least afford lawyers?
Well, thank you for the question. And again, I am open to considering any amendments and will consider any amendments that are put forward by this committee to ultimately improve this bill, to ultimately assist in the reduction of delays in the criminal justice system. When we're speaking about agents, the intent there was to assist in addressing the delay challenge. I do know that with respect to provinces and territories, many have and are the authorizing jurisdiction around programs with respect to agents. Some jurisdictions have addressed this. We are currently in conversations with the provinces and territories around these types of programs, but again, open to hearing concerns around that.
Thank you so much, Mr. Assassi.
Thank you, Minister, for being here. Also, thank you to your officials. Now, I would like to focus my questions on the significant issue of delays. In your opening remarks, you highlighted how important it is to you that we improve efficiencies in the system and that we reduce delays. So could you tell us specifically, given that you have more time now, what specific aspects of this bill will assist in that endeavor?
Well, thank you for the question. I have more time now. I like that. Okay. I mean, I really appreciate the question, and I know that this is the objective that all of us are seeking to address, to answer the calls from the Supreme Court of Canada in terms of a culture shift and addressing delays and ensuring we do everything we can so as to provide an accused person his ability to come to trial in a reasonable time, so cases aren't stayed. That is not the objective of anybody. The review of the criminal justice system that we sought to do is to ensure public safety, to show compassion for victims, and to hold offenders to account. In that capacity, and based on the instructions that I received from the Prime Minister, working with my colleagues in the provinces and territories and doing extensive consultations across the country, we came to the reforms that are being put forward in Bill C-75 around addressing bail reforms, streamlining the process with respect to bail, around looking at the administration of justice offences, which are a significant cause for delay in the justice system, looking at the reclassification of offences to enable prosecutors to make determination how to proceed, looking at preliminary inquiries, which was, like the other issues, strongly advocated for in terms of reform by provinces and territories, as well as looking at judicial case management and other efficiencies that have been articulated in C-75. It's a very detailed bill, as has been said. There's a lot of aspects and technical provisions contained within it, but cumulatively, this piece of legislation will, in my mind, and I'm confident, address the delays in the criminal justice system, along with other initiatives that our government has put forward and continues to do.
Thank you. Now, my second question has to do, as you know, in the Jordan decision, it was emphasized that all of the various actors in our systems are supposed to assist to make sure that we do not have delays in the system. Therefore, I was heartened to see in the news release that there was talk about how some collaboration had taken place between your officials and provincial officials and territorial officials. Now, in order to ensure that this proceeds in a standardized fashion, will there be any assistance from the government to the provinces and territories?
In terms of financial assistance?
Whether it be financial or otherwise?
Well, I would say that in terms of our collaboration, myself, the federal government, with the provinces and territories, my colleagues, that collaborative approach will continue. We have regular meetings among all of us to reassess and assess what we can do better, what we can do to address issues that are a challenge for all, as you say, actors in the criminal justice system, from prosecutors and defense counsel to judges. And again, the menu of bold reforms that we've put in place in terms of C-75 have come at the request of many of those provinces and territories. And last September, we got to a place where we could issue a joint press release on the need to ensure that these bold reforms move and that we continue to work together. So we're going to definitely continue to do that. In terms of resources, we always have conversations around the necessary resources. Provinces and territories have expressed to me, and I certainly suspect my officials, that a lot of these changes and reforms that are proposed in C-75 will assist in terms of the efficiencies and resources that are necessary in the criminal justice system. And again, those are an ongoing conversation that we will have.
Thank you. Thank you, Minister. Now I'd like to give my remaining time to...
Remaining time. We have, I'm sorry, we have now on five, there's essentially 5 slots left for the rest of the round. The only way we're going to be able to get this in while the minister is still here is to make them 3-minute slots. So I'm going to suggest to my colleagues that everybody will get a 3-minute slot going forward. Mr. Boissonnault, your slot.
Thank you, Mr. Chair. Minister, as you know, Section 159 has been on books in the criminal code for a long time, and it's an issue that the LGBTQ community has been asking to be removed from statutes for decades. I'm wondering if you can tell us why it matters to you as Minister of Justice and why our government is taking steps to make sure that this discriminatory provision is removed from the criminal code.
Well, thank you for the question. And as the member knows, the removal of Section 159 into Bill C-75, it has been something long-standing from C-39, which is a bill that we introduced to ensure that we do some charter cleanup. Section 159 in the Criminal Code has been rendered unconstitutional, is discriminatory, and our government is committed to ensuring the rights of all Canadians, equality for all Canadians. Another example would be the introduction and passage of C-16, which you're very familiar with in terms of gender identity and expression. So it's an ongoing commitment to ensure the human rights and equality of all individuals.
Thank you, Minister, and thank you for your work along with Minister Goodale on C-66, which we hope to see pass royal assent later this week. I want to thank you for your leadership on getting Section 159 to this point so that it can come out of the Criminal Code. It means a lot to the LGBTQ community. So a special advisor to the Prime Minister on LGBTQ2 issues, thank you for your work on behalf of the community, on behalf of our government. I sit on Indigenous Caucus on the government side, and we are interested, and I am particularly interested in how provisions in C-75 are going to help make lives better for Indigenous Canadians, reduce the over-representation of Indigenous peoples in our criminal justice system, to see a criminal justice system that is fair and sees people for who they are and the experiences with which they come to the criminal justice system. So if you could comment on that, I'd be grateful.
Well, thank you for the question and the work that you and all members do in terms of reducing the overrepresentation of Indigenous peoples in the criminal justice system. As I noted earlier, this is a prime objective in terms of the reforms that we're proposing with respect to bail and administration of justice offences. Not only do these offences more impact Indigenous Canadians, but also other marginalized Canadians, we're looking at making reforms that will ensure that law enforcement officers and the courts have regard to the individual circumstances of the individual before them. There are a number of other measures that our government is moving on and proposing around transforming the justice system with respect to restorative justice and other measures that seek to rehabilitate, seek to address prevention. These will assist in addressing the overrepresentation of Indigenous peoples in the justice system. Do we have more work to do? Absolutely, and we need to ensure that we're taking a whole of government approach, looking at health, looking at housing, looking at education, and looking at the ongoing reality of the colonial legacy.
Thank you so much. Mr. Cooper?
Thank you, Mr. Chair. Thank you, Madam Minister. No one disagrees with the fact that Bill C-75 does not change sentencing principles, but it clearly waters down sentences, going from a 10-year maximum to a 2 years less a day maximum if prosecuted by way of summary conviction. So that is clear, and that is the issue. And that is what is so concerning when we're talking about offenses such as impaired driving causing bodily harm, kidnapping a minor, arson for fraudulent purposes, and I could go on. But I want to ask you, Madam Minister, about some of the choices that were made in terms of listing through Bill C-75 offenses as hybrid offenses. Can you explain, for example, why you have decided to leave Section 249 sub 3, dangerous operation of a vehicle causing bodily harm, as an indictable offense, while making impaired driving causing bodily harm a hybrid offense?
Well, maybe I can address the initial comments that you made in terms of your stated you state that this is going to water down sentences. I would entirely disagree with that statement. You stated up front that this is not impacting sentencing principles. I would say that it's not impacting or watering down sentences that will come from the passage of this legislation. Prosecutors will have the discretion, based on the circumstances and the cases before them, to decide how to proceed, whether by way of summary conviction or by indictment. And this is not going to say that the sentence is not going to match the facts. I have confidence in the prosecutors in terms of making that decision, and ultimately it will be a judge that decides and determines what the appropriate sentence will be.
Yeah, well, Madam Minister, again, I've asked you a specific question, and that is to explain why, for example, dangerous operation of a vehicle causing bodily harm is an indictable offense, while Bill C-75 waters down sentencing for impaired driving causing bodily harm, making that a hybrid offense, among other offenses that are being turned into hybrid offenses, whereas other offenses that are very similar remain indictable offenses.
I'll ask Carol to go through the process with respect to the specific offense that the member raises.
So in response to the question, the approach in Bill C-75 is to come at it from a procedural perspective, and it's looking at offenses that are straight indictable now, 10, 5, and 2, as the minister has responded. So the approach is to, perhaps implicit in the question is that the name of the offense suggests that it is only capable of being committed in one way and in the most serious way. And I think, as the minister said in her opening remarks, offenses recognize, with the penalty structure, recognize that an offense can be committed in a variety of ways, and it can range from less serious, the gravity can be less, to the more serious on the scale. And that's the approach that Bill C-75 has taken, to provide a procedural option to Crowns in appropriate cases to seek to move in a more simple, expeditious way for cases that, based on existing case law, based on the circumstances of the case before the court, will dictate that it's more likely that case is going to get a sentence at that lower end of the spectrum for sentencing. It is not to suggest that the existing case law that says a serious case that in similar circumstances should attract a penalty of 8 years on a maximum of 10 should still attract a penalty of 8 years if it's appropriate and proportionate to other cases in similar situations.
Thank you very much. Mr. Fraser.
Thanks very much. I'll just make a brief comment and then pass to Ms. Khalid for the rest of my time. But I think this is a really important point just to pick up on regarding hybrid offenses. There's lots of hybrid offenses in the code now. The Crowns use their discretion every day to make a decision about whether to elect to proceed summarily or by way of indictment. And unfortunately, I think there is misinformation out there about the fact that this is something new, that summary offenses is a way to basically get off with just a fine. And I just want to put to rest that notion, because it's mischaracterizing the good work that Crowns do every day in using their discretion to make these elections. And I note that there are plenty of hybrid offenses on things that can range in seriousness, such as sexual assault. And it's really important that we use precise language when we're talking about the work that the Crowns do, and to not mislead people into thinking that this is an option that the accused has to make. And I'd now like to pass my time to Ms. Khalid for her question.
Thank you so much, Mr. Fraser. Thank you so much, Minister, for your time and for coming in today. I basically have a question about intimate partner violence. You know, the law and the judiciary has really been pushing the needle forward on this in cases like Iwanchuk, for where the defense of implied consent was rejected, and Lavallee, where the battered women syndrome was recognized officially. And now we have legislature. Can you please explain how Bill C-75 will move forward progress on intimate partner violence? And secondly, we know that the judiciary plays a huge role in this as well, in sensitivity and understanding gender diversity. Can you also, for the record, just explain what is the percentage of women on our benches, and how are we moving that forward as well? Thank you.
Well, those are two really important questions, and I'll take the latter first. In terms of the judiciary, I'm incredibly pleased to have a new judicial appointments process that has resulted in more women than men being appointed in terms of the bench. Overall, in terms of the Superior Court justices across the country, and the number is in the range of 38% now are women. The number might be a little bit higher. I'll get the exact percentage for the committee, but the number is continuing to increase based on the judicial appointments that we've been able to make over the course of 2 years. In terms of, which will have an impact in ensuring that the bench represents the diversity of the country. In terms of the measures, and I'll go quickly, Mr. Chair, of intimate partner violence, there are a number of measures, really important ones that we're proposing to strengthen our response to intimate partner violence. Around bail, imposing a reverse onus at bail. We are seeking to require the courts to consider whether an accused is charged with intimate partner violence when determining whether to release that accused person. We're clarifying that strangulation, choking, is an elevated form of assault. We are further, as I said in my opening remarks, defining what an intimate partner is to include former spouses, common law partners, and dating partners. We're clarifying the current sentencing provisions, and we're allowing for the possibility of seeking a higher maximum penalty in cases involving repeat intimate partner offenders.
You did indeed do that quickly. Thank you so much. Mr. McKenzie.
Thank you, and thank you to the Minister. Minister, there are some changes proposed that would allow for remote audio or video conference to be added to the code. And I'm wondering if you could explain how the rights of the accused to cross-examine the witnesses can be safeguarded, and how the whole process would work. Particularly, I think we have many courtrooms that are not equipped with video conferencing capabilities. It's probably fine in large urban areas, but in many parts of the country, I'm not sure how that you intend that to roll out.
Well, I think it's an important question. We're looking at including measures to enhance the ability of remote appearances, recognizing, as you quite rightly point out, that the technology is not necessarily there in all jurisdictions. That's something that we continue to have conversations about, and with my counterparts in the provinces and territories. But with respect to remote appearances, enabling and allowing the accused to appear remotely, that certainly doesn't take away from the ability to cross-examine an accused person, permitting participants to proceed by way of remote appearances, as well as potentially judges in particular circumstances. None of these measures are intended to take away from the ability to cross-examine an accused in an appropriate manner, but the intent behind these proposed changes, sir, is to assist in alleviating delays, travel, and the necessity to continue to delay if someone's not available and outside of the location.
So would you suggest that the federal government will provide sufficient funds for some of those jurisdictions to implement video conferencing capabilities?
Well, as I said, we continue to have discussions around remote appearances, working with our partners in the provinces and territories. I do just want to give my Carol an opportunity to speak to one specific point.
Just to point out that Bill C-75 does address some of the key principles that will govern under what circumstances would a remote appearance be appropriate, directs the court to consider all of the circumstances, including the rights of the accused for a fair, just trial, to make full answer in defense, and the circumstances where it would be appropriate, where the technology exists, and for what type of procedure. So that is addressed in the bill, and we'd be happy to answer the questions.
Thanks. And last but never least, Mr. Rankin.
I am happy to defer to my colleagues who haven't had a chance to ask questions or would like to ask more.
That's very
I got
kind,
my two
although,
out.
although every single member of the committee at this point has had the right to intervene, and I know the
Fraser-
minister needs to leave.
Mr. Fraser did not technically ask a question.
You're correct, but the minister actually needs to go at 5. So, Mr. Fraser, did you have a brief question that Mr. Rankin has so kindly offered you?
Thank you very much, Mr. Chair. I'll be very brief. Thank you, Mr. Rankin. Minister, thanks so much for coming. Question regarding the elimination of peremptory challenges. I know that in England they got rid of peremptory challenges in 1988 as a means to deal with more fairness in the system. I'd like to hear your comment on how you think eliminating peremptory challenges will make the criminal justice system more fair.
Well, again, I appreciate the question, and on our jury reforms, the elimination of peremptory challenges is one aspect of the reforms we're proposing in C-75. But by the elimination of peremptory challenges, which is the ability of a Crown or a prosecutor, a Crown or a defense counsel to eliminate an individual without giving a reason, has been considered to not provide or discriminate against a broad diversity of individuals sitting on a jury. What we're seeking to do is to ensure through the other measures of proposed changes is to ensure that there is the ability to have diversity on a jury. We're going to continue to work with the provinces and territories around other reforms with respect to jury selection, given the responsibilities that provinces and territories have around lists and bringing individuals in to serve on juries, but to ensure that there is a diversity of perspectives of individuals that sit on juries.
Thank you.
Minister Wilson-Raybould, Ms. Morency, Mr. Taylor, thank you so much for appearing before us today. It's very much appreciated, and we really appreciate you adjusting your schedule based on the votes. So
not a problem. Thank you, everybody.
Thank you. So we have an in-camera meeting, so we're going to suspend until we can clear the room.
you.